Hi, folks. I am Amanda J. Marshall. I am a patient's attorney in civil commitments working primarily in Clackamas County here in Oregon. And today I'm going to be talking to you about effective communication between patients and attorneys. So if you've looked me up, which I do not presume that you have, but if you have, you will notice that I've only been representing clients for about 3 years. And so if I were you, I would be asking, why the heck should I listen to this lady? I am unique in that I don't know of any other attorneys in the state of Oregon, or actually anywhere, that are practicing civil commitment law and have also sat in that patient or client seat in a civil commitment hearing. In 2012, I was put on 3 different mental health holds. The first one was dropped. The second one ended in a 14-day diversion, and the third one went to a hearing. So I get to the day of my hearing, and I get put in the back of a police car in handcuffs because that's policy. The officers, they were very nice. They were very apologetic, but I was still in handcuffs in the back of a police car. Drove up to the Multnomah County Courthouse. I was perp walked into the building. They did at least say that they would cuff me in front because I promised them that I wouldn't cause any trouble. So there was that. I was the second hearing that day. The first hearing was a lady who was floridly psychotic and looked like quite a handful for the attorney. So her hearing goes, she comes back into the holding area, which I am told is nicer than the inmate holding area. So that's something, still a holding area. And the attorney comes back a little bit after her. He's this like really young guy. He looks a little bit out of breath, and he comes and he sits down next to me and he flips open his file, takes this big breath, and then gives me this look. And I'm sitting there. I'm in a black suit. It's my my lawyer interview suit that I wear to job interviews. I told my family they needed to bring me that because you don't go in front of a court without wearing a suit. And he looks at me and he says, "You're an attorney." And I, give him some non-committal response. And he goes, "Do you ever want to practice law again?" And I give him some more non-committal responses. In my head, I'm thinking at this point, I really just want to die, and you can't practice law if you're dead. And so I kind of felt like that was a moot point. And he turns and he goes, "No, seriously, do you ever want to practice law again? Because if you get committed, that's probably not going to happen." And so I'm thinking in my head, okay, well, I do want to get out of the hospital. And it's possible at some point that I might want to practice law if I'm still around. So, okay, all right. Maybe I'll give this a shot. And so I tell him, maybe. And he asks me, "Are you willing to stay in the hospital for another week while I get the case together?" And I say, "Okay, sure." And so here we are 1 week later. I am back in handcuffs in the back of a police car, transported to the Multnomah County Courthouse for this second hearing, wearing my black interview suit that my family brought me. Again, don't go in front of the court without a suit. And so we go and do our hearing, and the attorney, he does a really great job, and we just barely get my hearing dismissed. And as the court gives its ruling, the judge turns to me and says, "Ms. Marshall, this is your shot. If I ever see you back in my courtroom on a hold again, I will commit you in a heartbeat." That day was a pivotal day for me. My attorney that day not only changed the direction that my life was going in, but the career path that I wanted to pursue. In 2012, I had already graduated from law school, and I was licensed to practice in 2 states. And before anyone gets stressed out about malpractice, I was licensed to practice. I was not practicing, so no worries there. But if I had gone through law school and passed 2 bar exams and couldn't figure out how to navigate my own case, how in the world was anybody else going to be able to navigate these cases? And so I decided that this was an area of law that I wanted to do. This is my backdrop for today. I'm speaking to you as an attorney who represents clients facing civil commitments, but also as that person who sat in that client patient seat and been there, done that. So our roadmap for today is going to look like this. I'm going to talk about how I start a case and how I introduce myself to my clients. Then we're going to go through 3 different scenarios that will highlight the 3 different kinds of, not the only 3, but 3 different kinds of clients that we work with. And then I will end with talking about the team or the collaborative approach that I've used in my own practice that seems to work pretty well for me. So, start of a case. The start of a case in Oregon is a notice of mental illness. This is the document that starts the hospital hold. So I've got that, I read that. Then I read the investigator's report that is recommending a hearing. This gives me a little bit of history. It gives me what's happening now. It tells me who my players are, my potential witnesses. And then it gives me the investigator's opinion about whether my client, whether they think my client's a danger to themselves, a danger to others, or unable to care for their basic needs. So I print that out. I head off to the hospital. I'm going to talk to my client. I'm going to pause here for a moment and make a pitch for situational awareness. I'm not going to talk about situational awareness in my talk today, but if you don't know how to navigate a psych unit and be situationally aware, learn about it. The way that I learned about it was from being a patient in multiple psych units. I do not recommend that as a learning strategy, but it is important to be situationally aware in a psych unit. If you don't know it, go learn about it. On the plus side, as a patient's attorney, I'm usually pretty well liked because I'm seen as the ticket out of there. And at this point, the staff know me pretty well. They don't worry too much about me. I don't know if in the past they were actually worried for my safety or if they were worried about the havoc that I may wreak for their patients by talking about holds and civil commitment hearings. So I'm there in the hospital. I've got my paperwork. I walk into my client's room and I say, "Hi, I'm Amanda. I have been assigned as your attorney if you would like me to be. We have a court hearing tomorrow. Did you know about that? I would like to talk to you about it." I want to break this down for you. So first of all, you need to be informal. You are starting a conversation and you need to be approachable. We have very little time to build rapport with our clients and build our case. So be informal. Don't be another, stuffy professional they have to talk to. The next thing in my intro is that I have been assigned as your attorney. Yes, we are appointed. Just as there are a lot of stereotypes about people with mental illness, there are just as many about appointed attorneys or public defenders. And I find it's easier if you just avoid the word appointed. So I've been assigned. I have been assigned as your attorney if you would like me to be. Our clients have the right to represent themselves. I have never had a judge actually allow one of my clients to represent themselves, but they have the right to do that and they have the right to ask for it. There is very little choice, very little autonomy that you have when you are on a hold in a psych unit. And so any autonomy that I can give back to my client, I'm going to do that. What is not in my intro? What is not in my intro is, can I talk to you? Don't ask your client if you can talk to them, because if they say no, then you're done. Your conversation is over. Your drive time to the hospital and back was for a 15-second conversation. Hi, can I talk to you? No, you can't. Probably accompanied with a get out of my room. So let's launch into some scenarios. So we have our first scenario. We have all dealt with these kinds of clients. These are your angry, loud, yelling clients. I will look at my investigator's report. It usually says something like, won't talk to the investigator, threw the citation across the room, yelling about being held against their will. So I've got my report. I've got my notice of mental illness. I go drive to the hospital and I'm getting ready to talk to my client. A note here, situational awareness. And I walk into my client's room. Hi, I'm Amanda. I've been assigned as your attorney if you would like me to be. We have a hearing tomorrow and I'd like to talk to you about that. And I get a response something like this. Yeah, I know about the hearing. These jerks, they're keeping me here for no reason and no one will listen to me. And sometimes they are banging on walls or on the nurse's station. And your conversation is escalated before you can even begin. Now I want to pause here because I want to highlight something that this client has said. No one will listen to me. When you hear a client say, no one will listen to me, I want you to full stop and think about where this client is. This person is being held against their will. They probably don't understand what's going on. They can tell that people are telling them half-truths, and they don't feel like anyone is listening to them. Your response should be, I want to listen to you. I have had this completely change my client's demeanor. They sit down and talk with me, and I have had this have no effect whatsoever. But I can promise you that it will never hurt your relationship unless you don't have enough time to sit down and listen to them. If you tell them that you want to listen to them, you need to have the time to sit down and listen to them. So don't make any promises you can't keep. That'll mess up that little bit of trust that you had going. What is the most important question for a patient's attorney to ask? Do you want to stay in the hospital or do you want to leave the hospital tomorrow? I can do an entire hearing off a yes or no answer to this question. I don't want to. I would rather have more information. But if I can get a yes or no to this question, I have my direction. I can do a hearing. How do we get more info? I'm in my client's room. Hi, I'm Amanda. I have been assigned as your attorney if you would like me to be. We have a hearing tomorrow. Did you know that? I would like to talk to you about that. And their response, as before, yeah, these jerks, they're keeping me here for no reason. So I often use this phrase, okay, let's talk about that. It is an incredibly versatile phrase, and just keep it in the back of your brain as we go through here. I'm going to elicit help from my client. How are we going to convince a judge that you will be safe if you leave the hospital tomorrow? This is an excellent place to explain to your client what a civil commitment hearing is. A lot of folks, unless they've been through it before, they don't know what a civil commitment hearing is. A lot of attorneys don't know what a civil commitment hearing is. And so explaining what it is, this is a good place for that. So I tell my clients that these are safety hearings. This is a hearing to make sure that you and the other people around you are safe. This is not a criminal hearing. There are no charges. There's no jail. You're not in trouble. You didn't do anything wrong. This is all about safety, your safety and the safety of those around you. So then you get, well, I'm safe. I don't understand why these people don't think that I'm safe. Okay, let's talk about that. Other people are going to tell the judge that you were walking down the street with a hatchet and yelling at people. Yes, but I was doing that because God told me that I needed to protect them and they weren't listening to me. Let's talk about delusions. Don't challenge delusions. This will drive a wedge in the trust that you have built with your client. Don't fuel them either. That's not good. Let the mental health professionals deal with delusions because you as an attorney can sidestep. You steer your conversation back to safety. I hear you. Others, they're going to tell the court that that isn't real. And here's the thing. The court doesn't care if it's real or not. What they care about is that there is a person walking down the street with a hatchet yelling at people. Can you see why that might frighten folks? So how are we going to convince a judge that you will be safe? We have a conversation about this. Maybe you leave the hatchet at home. What you did this time, that didn't really work because you ended up here. So What could you do differently next time that a judge might think is safer? I'm going to take a moment here to talk about a concept that I call safe people. I don't really use this in a court hearing, but I have had some clients give me feedback that this was helpful to them. And so I figured I'll just throw it into my talk here. With folks who have delusions, I ask them, who are the people in your life that know you and care a lot about you and will tell you the truth no matter what? Sometimes as kids, sometimes as a therapist. Who are those people? Identify those people when you're feeling good. Maybe write them down somewhere, put them in a safe place for when you're not feeling good. And then I tell them, sometimes our brains play tricks on us. And we need to turn to our safe people to help us figure out, is my brain playing a trick on me? And if your safe people say, yep, that sounds like a trick, and you've identified those folks when you are feeling good, you can trust them a lot better when you're not feeling good. And so some of my clients have found that helpful, some of them not so much. Probably not going to be able to use it too much in a hearing, but it's something you can try. And then I steer the conversation back to safety. How are we going to convince the court that you will be safe if you leave the hospital? A side note about anger. We're all here together. You probably already know this. Anger is a much safer emotion to show to other people than sadness. Anger is much safer than confusion. Sadness and confusion leave you vulnerable, and you can't be much more vulnerable than when you're on a mental health hold and you don't feel like you belong there. So let's go to scenario number 2. I get my investigator report. It says, Tom is on a hold after stopping his meds and decompensating. All right. I have my investigator report. I've got my notice of mental illness, my hold document. I print them out. I drive to the hospital. I walk into Tom's room and I say, hi, Tom, I'm Amanda. I have been assigned as your attorney if you would like me to be. You have a hearing tomorrow and I would like to talk to you about that. Well, I don't want to be here. Everyone keeps telling me I need to take meds, but I don't want to take meds. I don't like meds. Okay, let's talk about that. How are we going to convince a judge that you will be safe if you leave the hospital tomorrow? Well, I don't like meds. Okay. Others will say they're worried because you've stopped taking your meds and that's landed you here. Well, but I'm safe. I have a place to live. I live with my family. I don't need meds. I don't like them. I'm not taking them. What if your family says that you need to take meds to keep living with them? Well, screw them. I'm not taking meds. I hate meds. What if a judge says you can go home if you take your meds? Oh, well, when a judge tells you to do something, you have to do it. So if a judge tells me I have to take my meds, I will take my meds. Wait, seriously? Kind of unbelievable, right? Except it's not. This was an actual scenario that we had in our county. The court actually allowed Tom to be on conditional release. The terms were he lived with his family, he had to go to therapy, he had to take his meds, and he had to check in with the judge in a couple of months. As far as I know, he is doing very well because I haven't seen him on any of my list of holds for quite some time. And so I hope that he is just out there living life and not having to deal with civil commitments or holds anymore. You may never have a Tom. I probably won't have another Tom. But the point of this story is you need to find the motivator. Find your client's motivator. For Tom, his motivator was, I'll do it if a judge tells me to. I don't want to. I don't like it. I actually hate it. But if a judge tells me to do it, I'll do it. So what are some other motivators? If this were live, I would ask people to give me some. But if I pause here, I think I'll look pretty silly. So I'll just keep going. Kids. Kids are a good motivator. People will do a lot of things for their kids. Arts, music, playing guitar, singing in choir, And I've had people want to get out of the hospital so they could do those things. Pets. Pets are a surprisingly big motivator if you've not figured this out yet. Sometimes they're bigger than using family as a motivator, especially if your client doesn't live with family members, they live with their pets. Their pets can be a bigger motivator to getting out of the hospital to them than their sister that lives a couple states away. So once you find the motivator, use that motivator. Okay, let's figure out how are we going to get you out of the hospital so that you can play guitar, so you can go sing in choir, so you can pet your dog or your emotional support iguana, or whatever. We need to convince a judge that you will be safe to do that. Help me out. You know your life and your resources better than I do. How are we gonna make this happen? Let's go to scenario number 3. Scenario number 3 is about clients that aren't talking. My investigator's report is going to say something like selectively mute. I hate the term selectively mute. I find that it is incredibly rare, actually I've never found, that someone who has been stuck in the hospital for a week, facing potentially months longer being stuck in the hospital, that they don't want someone to understand them. Another thing I may see in my investigator's report is catatonia. Now, this is harder for communication, but catatonia shows up in a lot of different ways. And so don't write off your attorney-client conversation yet. Got my investigator's report, got my notice of mental illness, go to the hospital, walk into my client's room or wherever they're at. Hi, Alice, I'm Amanda. I've been assigned as your attorney if you would like me to be. We have a hearing tomorrow. I would like to talk to you about that. I notice as I say these things that Alice is, nodding along, following what I'm saying. And so I ask Alice, do you want to stay in the hospital or do you want to leave the hospital tomorrow? Can you give me a thumbs up or a thumbs down? Alice gives me a thumbs in the middle. She looks like she wants to tell me some more, but she can't. So I look around the room, I see she's got a journal and she's got a pen. And so I say, oh, can you write it for me? And I hand her those things. She gets some hope on her face, starts writing furiously in this journal. I can't read it. It is completely illegible. I have absolutely no idea what it says. And she looks at me with an even more desperate look on her face. So I look at my investigator's report and I see that it says that she has an office job. At this point in time, I was carrying around a computer, my laptop that could fold all the way back and had a stylus so I could take notes on it. I don't carry that one anymore because it broke, very sad. But at that time I was carrying it with me into the hospital when I interviewed clients. And so I closed out all my confidential things and pulled up a Word document and handed her my computer. And this rush of relief comes over her face and she just starts typing furiously. The first thing that she types out is, tell the nurse that I hate the hospital mac and cheese and please stop ordering it for me. Fair. Okay, I'll do that. All right. Cool. Next, she types out that she is not refusing meds. She is refusing the one med because she's had a prior bad reaction to that med, but she's totally willing to try some others. So our conversation keeps going like this. I ask a question out loud. She types me her answer. She's actually quite chatty over typing. So the next morning I come to the hearing. I bring my extra computer so that she can type out whatever she needs to during the hearing to me. And, we only have 24 hours to talk to these clients. And so I had not discovered this communication method with Alice until about 9 p.m. the night before the hearing. So nobody else really knows about this. So the state comes and they present Alice as refusing to speak with medical staff, refusing to eat, and refusing meds, and therefore not a good candidate for voluntary treatment. The court graciously allowed me to read into the record the things that Alice wrote, as though that was her testimony. And so I was able to present a case that showed her as wanting to communicate with the medical staff, but couldn't, hating hospital mac and cheese, so she's not going to eat it, but she's willing to eat other things, and not willing to take that particular med because she had a bad reaction in the past, but willing to take others. The court dismissed the hearing because she was willing to stay in the hospital and get voluntary treatment. She didn't like that she couldn't communicate with other people any more than the medical staff did. Moral of this story, be creative. Use all the tools at your disposal. I use thumbs up, thumbs down all the time. I use thumbs up, thumbs down with people who will talk to me. Sometimes it's just easier to, get them to interact. I have used blink once, blink twice. I've had people write out their answers. I've had people point at things. I've done the charades thing. It doesn't work very well for me. It's probably because I'm really bad at charades. But if that's your thing, cool. Be patient. If you have a catatonic patient, they might need a really long time to answer you. If you keep asking them questions, they're going to give up trying to answer you because it's just too many things. So don't be afraid of silence. If you ask your client a question, and then I'm really bad about continuing to go on, I will come back to that original question, and then just sit there. Just give them, even one or 2 minutes. There is stuff going on in their brains. They just can't get it out. And sometimes you'll sit there for 2 minutes and you won't get anything. And sometimes you'll get something. So be creative. Use what you can. Use the things around you. I'm going to finish out my talk talking about the team approach or the collaborative approach that I use in my practice that works well for me. We all have a common goal. The common goal is to get this patient out of the hospital and to stay out of the hospital. We want this person to be able to live in the community, to be able to maintain in the community, not be in and out of the hospital. And so I am collaborative in these cases until I can't be. Negotiate with the state about less restrictive options, conditional release, outpatient commitments, assisted outpatient treatment. Talk to families, find out what are the terms that you would, allow your loved one to come home, because by the time you go to a commitment hearing, families they're out of ideas and they've tried really hard and they don't know what to do. And so involve them and then negotiate those things with the state. See what you can do. Use other professionals' expertise. Ask the mental health professionals, maybe the outpatient folks, do you think this harebrained scheme of mine will work? And they'll say, no, you're crazy, try again. And you go back to the drawing board. Talk to nurses. Ask if certain communication styles work better than others. Talk to social workers. What are the resources? What has this person already tried? What is still out there? Use your resources to help your client with their resources, because I can pretty much guarantee you that if you don't know about the resource, they're not going to know about the resource either. And so get familiar with the resources in your community, get familiar with the providers in your community, and just be collaborative until you can't be. So I want to thank you for listening to me and allowing me to share my story. If anybody has any questions, please feel free to reach out to me. I am obviously very open about my story and my experience. I invite people to ask me any question they have. The worst that I can say to you is, I'm not going to answer that. If it's a really personal question, I'm actually probably not going to say that. I'm going to say, let's go have coffee. I'll talk to you about that over coffee. Because if my experience can help even one other person's experience be a better one, then I count that as a win in my book. Thank you.